What's up? What's up? What's up? Good morning, Northwood Press. Good morning, Indiana God Level. How you doing? And good morning, Truck Scott. Please don't change your name every freaking day. First your shakes, now your trucks, now your shakes, now your trucks. Make your mind up, bro.
It's been trucks the whole time. Hi, everybody.
No, when I'm going on a panel, it shakes.
Oh, okay.
Yeah. Or you pull like trucks, guys slash shakes.
Right. Have a little bit of both.
Oh shoot, duh. Okay. Video fire.
I got a new avatar today.
Ah, you do.
She might be a little risky for YouTube, though.
Yeah, who cares?
Mm,
After a judge sentenced another judge to jail time, chaos erupted in an Ohio courtroom. And taking the defendant into custody wasn't so easy, as a court officer had to drag her out. Former Cincinnati Judge Tracy Hunter was sentenced to 6 months in jail back in 2014, but she's been appealing the ruling ever since. She was convicted of misusing her position as a judge to help her brother, who was facing an employment dispute over his job in the county. Her lawyer has claimed her actions didn't break the law.
Judge Hunter has gotten up each morning not knowing whether that was going to be the day that she was going to have to go to jail.
But now that all of her appeals have been exhausted, she had to face the music in court.
What she wants is to control the facts. What she wants to do is write the law, and what she wants to do is play by her own set of rules right up until today.
The case has drawn outrage from the African American community, who say Hunter is being treated unfairly. Several people tried to protest her sentence. One was restrained by deputies and released after being found.
Okay, what do you guys think?
I mean, she should have took hers doing all that bad stuff, helping her brother. She should have took that and ran with it and manned up to it. Because she was one in the wrong, not nobody else.
Mm-hmm. Wow. Can you imagine?
She abused her power.
Power, yeah, and she said she doesn't know that bullshit.
Right.
Wow, 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 wow. Next video coming up.
First indicate the first responsibility of any judge is to uphold the law. And our system of law is eroded, and there is a lack of trust in our judicial system if people who are tasked with upholding the law decide to subvert it for their own personal gain. Now, Ms. Brennan, you have taken several oaths in your life. You took an oath first when you became an attorney. This is the same oath that every attorney in the state of Michigan takes. And part of that oath was, and I will quote, "I will employ for the purpose of maintaining the causes confided to me such means only as are consistent with truth and honor. I will never seek to mislead the judge or jury by any artifice or false statement of fact or law." You also took took an oath when you became a judge, Ms. Brennan. You took an oath to uphold the Constitution of the United States, the Constitution of the state of Michigan, and the laws of the state of Michigan. And when you were a judge, you required, as all judges do, people who came before you to tell the truth. It doesn't matter if it was a family law case, or a civil case, or a criminal case. you required them to tell the truth. And the reason you, like all judges, required people that came before them to tell the truth is because the whole purpose of a criminal proceeding or a civil proceeding or a family law proceeding, it really is a search for the truth. And when individuals come into court or go to a deposition and knowingly lie, that undermines that search for the truth. That is why we have perjury, serious crime in Michigan, because our society simply does not accept people who actions in which people come into court and lie, or come to a deposition and lie. I don't doubt that you regret your actions, Ms. Brennan. I don't doubt that you were genuine with what you said. And I appreciate what you had to say. But there's also another oath that you took, and you took an oath during the deposition in your divorce case. Another oath, and you swore to tell the truth in that deposition. And that's why we're in court today. Because on that day, you decided that you would lie to benefit yourself and to protect yourself. And even though you made others and required others to tell the truth, when it came your time to have to raise your hand to tell the truth, you decided that you weren't going to do it. And so the request for probation, as far as this court is concerned, based on these actions, which are utterly unacceptable for a person who took an oath many times or a couple of times to uphold the law, requires others to tell the truth. A probationary sentence under those circumstances would be wholly inadequate. These actions, it would be an understatement to say, are unacceptable. And that behavior is unacceptable. And a jail sentence in this case for those reasons would be more than appropriate as far as this court's concerned. And it will be the sentence of this court. The sentence, Mr. Brennan, within the guidelines that were agreed upon, to 6 months in the county jail, followed by 18 months probation. Is there anything for either side?
No, Your Honor.
With regards to anything?
What do you guys think about it?
That was a good one.
Yeah,
And right.
yeah, it was good. Hey, Angel.
I mean, he was right though, right? From what I was listening, he handled it respectfully and actually like a judge should, even though it's another fellow judge.
All judge is not corrupt. All judge is not corrupt. I'm getting,
Right.
Most stuff is, a lot of judge isn't,
Right. And that's what a lot of the auditors and the activists, I guess I should say, not auditors, the activists, some try to portray, good, some try to portray bad, some just want to educate. I mean,
you have to listen to the whole fact,
right? Get the whole story, yes.
But the problem is how to get camera inside the courtroom.
Right.
That's the problem. They need to pass the law for cameras to be allowed. You know what I mean?
Well, and it should be, because it's definitely unconstitutional. But remember, the Salem witch trials is one example, I believe, that why they don't want them in there and cameras in the courtrooms. Well, I mean, even then, back then, they didn't have cameras. But
if you can't have no cameras, get a cell phone, put it in the pocket, and record it.
I mean, you can have audio, so you can also get a tape recorder.
Yeah.
They don't want you to have your cell phone because everybody already has a way to record. That's why a lot of cops are having issues with the hell cameras now, because everybody has a camera.
That's why.
That's why we're getting more footage of Karens and whatnots, everything. You get footage of everything. You have the whole story off your camera. It's the, how do they say, the eject, no, is it, I can't say it right, how they say it.
Good point.
But yeah, it's the, crap, I always want to say the wrong word. I have it in my head though. You guys know what I mean.
Mm.
It's like the objective version without any lies. So it tells the truth.
Yeah.
But so with a recording, that's why there's those wiretapping laws.
Mm. And plus, you gotta watch. They have a tape recorder too. A watch.
Well, I mean, anybody can. That's how they used to get people. They have informants, and they, yeah, unbiased. Thank you, Angel. On
Thank you,
hell,
Angel.
on hell.
Board of Judicial Conduct the most corrupt entity in Tennessee's criminal justice system? I'll let you decide. I compiled data relevant to complaints filed against judges and judicial commissioners from the Tennessee Board of Judicial Conduct's website, and this is what I found. From January 2021 to September 2023, there were approximately 927 complaints filed against judges and or judicial commissioners. I say approximately because the website is missing a few months of data. But based on what I've discovered thus far, the inclusion of that data would probably not benefit the Tennessee Board of Judicial Conduct. They also conveniently added an other section to the outcomes of their investigations, which was about 9% of findings. Lord knows the word other is about as arcane as you can get in an investigatory outcome. But I'm sure they're not trying to hide anything. Of those 927 complaints, 842, or about 91%, were dismissed. Of those 842 dismissals, a full investigation was not conducted in 98% of them, meaning they just dismissed them with minimal effort. Out of the 927 complaints, do you want to take a guess at how many resulted in a reprimand? I'll give you a few seconds to lock in your answer. You got it? If you said 20, you were correct. Surely the only entity responsible for holding judges accountable in the state of Tennessee isn't the most corrupt entity in our state, right? Well, we put it to the test by gathering substantial evidence on multiple judicial commissioners in a Middle Tennessee judicial commissioner's office. We discovered both criminal activity and ethics violations on behalf of 7 judicial commissioners in this office, which resulted in either terminations or resignations. But when we submitted the evidence to the Tennessee Board of Judicial Conduct, to my surprise, it was dismissed without an investigation even being conducted, which aligns perfectly with the data that I compiled. Their reason for dismissal was a lack of probable cause, but we all know that isn't true. I conducted investigations for almost 10 years as a law enforcement officer, which resulted in hundreds of convictions. I know we had probable cause because we submitted physical evidence. But this is where things get a little weird. This man, Judge D. David Gay, was the chair over the Board of Judicial Conduct, and he just so happened went to law school with this man, Judge Tom Taylor, who was the judge in charge of the individuals who committed the offenses. We can only speculate as to what happened there. It's not like judges look out for one another or anything. Do you believe in coincidences? If that doesn't irritate you, this will. Any complaint filed with the Tennessee Board of Judicial Conduct and their outcomes is inaccessible by the citizens of this state. So let me get this straight, Tennessee. An entity composed of multiple public officials that investigates other public officials is not public information? Let's not make it obvious what's going on here. Oh, it gets better. There are 8 current or former judges, along with 2 attorneys on this board. That isn't a conflict of interest at all. Only 6 individuals on this board have never been an attorney. But, wait for it, 2 of them are from Memphis, the exact same place the former chair went to law school, and one of them is a retired FBI agent. Coincidence? There's that word again. Criminal justice reform is a must, ladies and gentlemen, and this man right here stated it was a priority when he ran for governor. I have said for years that judges have too much power and not enough oversight. If you are an elected official with the Tennessee legislature, dismantling the Tennessee Board of Judicial Conduct is a great place to begin for criminal justice reform. Make all complaints public, which they should be anyway. And if you want true accountability, which we all know you don't, this is how you hold judges accountable. Each month, normal citizens from across the state are selected to serve on the Judicial Conduct Board, much like citizens are selected to serve on juries and defendants are found guilty or not guilty by juries. Those citizens review complaints just like a grand jury would do and determine whether probable cause is existent or non-existent. I think I speak for the overwhelming majority of Tennesseans whenever I say that if you did it that way, 91% of complaints wouldn't be dismissed, and there would be a lot more than 20 reprimands out of 927 complaints. But that's not what you want, Tennessee legislature, because judges have too much power and control over you. As a result, I believe we should start a petition to change the name of the Tennessee Board of Judicial Conduct. And I have the perfect one for it. After seeing the data, I vote that we change the name from Tennessee Board of Judicial Conduct to the Tennessee Board of Judicial Protection.
Wow. Good said and done. You know?
Definitely.
Yep. Very good. Okay, video number 4 coming up.
You write this down. 80 people a day die in America from gunshots.
And 75 of them to 78 of them, statistics by the Uniform Crime Report by the FBI and the UN study on violent crime, 78 of those 80 are let out of their cages by corrupt judges and prosecutors who know that recidivism is out of control, know that they'll commit the crimes again, and they let them walk through plea bargaining, early release, and programs.
They still
Kiss
can't-
my ass.
Yeah.
Where you have the most armed citizens in America,
Yeah.
you have
I
the
understand.
lowest violent crime rate, where you have the worst gun control, you have the highest crime rate. Pierce, choose one. Do you want a lot of crime? We have it. Gun-free zones. Do you want less crime? We have that. More people with concealed weapons permit. Why do you guys resist that statistic?
Well, don't say you guys.
It's you guys.
No.
Well, unless you're playing the devil's advocate.
I can play any advocate I like.
You're
It's
doing
my
a fine
show.
job.
Right.
You're playing the idiot's
not-
advocate
it's
here.
not- that's not the idiot's
More
advocate.
guns equals less crime.
You're-
Period.
Let me.
Wow. What do you think?
Yeah, that was a good one.
Yeah. Who was the actor? I never seen him before.
The guy, I don't know. I guess he's a YouTuber, right? Or you're talking about the guy, the head guy that he was yelling, the one he was yelling at, the other guy.
No, the guy with the cowboy hat.
Oh
Yeah,
yeah, I
the-
don't know.
the-
I think he's a YouTuber. I think I seen him
Oh.
as a YouTuber. The other guy is I don't know his name, but he's the top guy too. He's a reporter.
Yeah, I know from Tucker, whatever his name is. Pucker.
Yeah,
You know?
I don't know his name.
He's a
He's
jerk
not very.
anymore.
I mean, he's good. He just needs to do better. Ask better
Yeah,
questions, or
maybe he must be new property. I don't know.
no, he's been on the team for a minute. Oh, you mean the YouTuber?
Yeah.
I think he's a YouTuber guy. We'll have to find his video.
Okay.
Write this down.
Somehow.
80 people a day die in America from gunshots.
And 75 of them to 78 of them, statistics by the Uniform Crime Report by the FBI and the UN study on violent crime, 78 of those 80 are let out of their cages by corrupt judges and prosecutors who know that recidivism is out of control, know that they'll commit the crimes again, and they let them walk through plea bargaining, early release, and programs.
They still
Kiss
can't-
my ass.
Yeah.
Where you have the most armed citizens in America,
Yeah.
you have
I
the
understand.
lowest violent crime rate. Where you have the worst gun control, you have the highest crime rate. Peers, choose one. Do you want a lot of crime? We have it. Gun-free zones. Do you want less crime? We have that. More people with concealed weapons permit. Why do you guys resist that statistic?
Well, don't say you guys.
It's you guys.
No.
Well, unless you're playing the devil's advocate.
I can play any advocate I like.
You're
It's
doing
my
a fine
show.
job.
Right.
You're playing the idiot's
not-
advocate
it's
here.
not- that's not the idiot's
More
advocate.
guns equals less crime.
You're-
Period.
Let me.
Yeah, Andrew. Andrew, he's telling it to kiss his ass, Andrew. You know?
Well, I mean that one too. I mean, I know that's the same one.
No, I know. I kicked the wrong one.
No, it's fine because now I mean, like I watched it, but that one was good because he makes a good point. The gun-free zone is where the kids are, not even kids, or adults are going and taking the guns to.
Mm-hmm.
So you're saying it's fair game basically to just go and take out all the kids. That's not the smartest thing to do, but it is because they're the future. Well, we don't need them. Let's just let the old people run it. Yeah, play the next one when you're ready. I'm partaking in an afternoon an early morning smoke break. I think we lost Gregory for a minute. What's everybody up to? What's Angel up to?
I'm here.
There you are.
Is it time? 8:45. 4 minutes. 8:45. With Travis.
Notice how he looks in the direction of the prosecutor. Again, watch the full video to get full context of what is happening.
Good morning, Your Honor. Thank you. That's all I'm ready on for now. Thanks.
Sanchez.
And Your Honor, Mr. Torrance is here today. We're ready on Mr. Sanchez.
Excuse me.
He's not present, Your Honor.
All right, we'll set a bench warrant, $15,000 cash, commence bond forfeiture.
Thank you, Your Honor. That's all I have this morning. If I could be excused.
We're going to take him into custody.
Chair, Court, Mr. Sanchez is standing in the...
And we're going to execute the warrant. So we'll see if he comes in here, calls his case. So he's probably calling his attorney practically out there.
So easy.
Because he wants it executed. He's not going to come save him, I'll bet you. So we're going to execute the warrant. I just want to make sure we see you before you go back. Your case was already called this morning. We just saw you arrive about 10 minutes ago, which would have been a quarter to 11.
I've been here since 9:08. Could I just know what time the warrant was issued? What time did my attorney leave?
That you can ask your attorney about that, but we didn't issue it until after 9, and you're here way after that.
Wow.
Yeah. I seen this one. I watched it. Mm-hmm. Yep.
That's screwed up, isn't it?
It's hella screwed up. And remember, you can't have cameras in the court, but they do record it. You have to request the document.
Who ever asked cash for a bond?
I mean, they used to. It used to be back in the day.
Man. Yeah, I don't play RPGs or it's small. Why you don't play your girlfriend oh never mind, Angel. I won't start with you. Forget it. Not worth it. Nah.
Okay, play the next video.
yeah. Next video. Nah. It's too early.
Yeah, way too early for that.
Yeah.
I can't with y'all too.
Yeah.
To help me. Oh, okay. Who's questioning this witness? Hello, which witness? Your next witness.
These don't have anything to do with it.
Yeah, we're just entering them.
These are just records. We're just doing it now.
So is it a secret who's going to be questioning your next witness? Because I'm going to find out in like 3 minutes.
No.
Who was doing it?
The records don't relate, but if we call the witness, it will be me. I'm assuming you're talking about that.
Who is your next witness and when are they being called and which attorney is going to question them? Let me be clear if I wasn't before. Because if these don't have anything to do with your next witness, then why are we having the jury wait outside right now?
Just because we were trying to move everything in because in terms of timing, we do it now.
In terms of timing, it would be much better to do it during the lunch break when the jury needs longer than you all. So we'll go ahead and pass on this. Let's bring the jury in, please.
Your Honor?
Yes?
At this time, the defense rests, other than putting in our records.
We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and bring your records.
To B. Nicholas Cruz Henderson, episode 1 record.
Let me just stop. State, are you going to have anything ready for today?
No. We're expecting, there was 80 witnesses. We're waiting for 40 more witnesses.
I just want to say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision until this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly, I have never experienced a level of unprofessionalism in my career. It's unbelievable.
So, Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22
You know what, I don't want to hear it. I don't want to
Well,
hear it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend myself.
you can do that later, you can make your record later, but you've been insulting me the entire trial. So blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, this has been long overdue. So please be seated, you can receive the evidence, I will receive the evidence, and then you can put whatever you want on the record at the end. Go ahead.
2B, which is Nicholas Cruz Henderson Records, episode 1.
I'm sorry?
Episode 1, Henderson Records for Nicholas Cruz.
Damn, what a jerk she is.
I think she
Yeah,
went
that's
about
right.
it wrong, but I think she was right though to call her out, or at least to say something about,
Yeah, but the lawyer was there. You know?
I guess you have to watch the whole story thing. But
Yeah, the judge gotta be patient. You know?
right.
The judge goes,
She has to leave her bias at the door. Yeah, everybody should
he,
actually, but
he sure don't say nothing to the judge. You know, they just okay. Things happen. You know, don't like that. Don't turn down. Don't let the judge make the lawyer look bad. You know, it's bad. You know.
on hell, you can't say that. That's not nice. But I'm over here laughing.
I agree with Andrew. I think Andrew meant the judge is wrong for yelling at that
She needs some butterhead cream.
at that 20 a.m.
Can't say that. Next.
Really did. You know, I agree with him, Angel. You know.
He knows I'm laughing at it because it probably is a woman thing.
Mm-hmm.
We all get in our emotions, attitudes.
My understanding of
you should have come and asked. Why would you think that made it okay for you without any advance notice to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
With all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. Don't get brazen with me. Attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't get...
Did you see both lawyers on the both sides looking at the judge? What the hell are you talking about?
Yeah.
You know?
I think that's pretty much why I think he got acquitted. Was because of that stuff.
Yeah, it's like
it was all like a show.
Yeah, it's like you could bring a witness anytime you want. You know?
When you can't, you have to have it on paperwork that you're gonna have a witness that day. Don't you? You have to file I think you have to file paperwork.
Depends what state you're in.
Yeah.
I think it goes by states. I'm not sure, you know.
So everyone definitely check out your state.
Yeah, it
codes
depends
and
what
laws.
state it is. Yeah. You know, that's a good topic. Know your laws in your state, you know. But remember, sometimes it's an outdated, you know, it could be wrong, you know. It's like it's like if Andrew's smoking a car, if it were a judge, I'll arrest him.
Why? On what grounds?
He's ugly.
You can't do that.
I know that. I know that.
That's why you would never be a cop.
I wanted to have I'll be kicked out of the. I'll be kicked out. I'll be like, they'll be judging me, huh?
They'll kick you out before you even start.
Well, that's good, Taps. Make it the moolah.
Yep, always good to make money.
My understanding of
You should have come and asked. Why would you think that that made it okay for you without any advance notice to bring this matter before the jury? You are already, I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
With all due respect,
I'm not going to rehash the motion. That's absolutely untrue. And there's no. Your arguments of record, my comments are of record, and why I ruled as I did is of record. Don't get brazen with me. Attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't get...
That's why I like you, Andrew. That's why I like your brother. You have evidence. You know, I like that, brother. You know that. That's why I like Andrew. You know. You know.
I'm one of the referrals. You know? I'm one of the referrals. Because yeah,
you be a good lawyer. You know.
There's his calling. Become a lawyer, Angel. Take on all the civil rights violations. I've thought about being a lawyer.
Belabor the point,
I don't want to lie to
that was where I was coming from. Was there's been a change in the testimony of the defendant today that I think makes that evidence. It's admissible and much more relevant than it already was, and I thought it was already relevant. And the court is. I do want to be clear.
So
also,
I'm just here on the sidelines, just.
Well, you.
Yeah, I had made a ruling that the evidence wasn't coming in, and you decided that it was.
If I could just respond to that briefly, Your Honor, I was about to say, I did not interpret your ruling as an absolute. We've had 3 state motions in limine. There was one in which we asked the court to introduce evidence that the defendant was at Pudgy's bar with Proud Boys, and you were clear that is not coming in. There was.
You know, don't get into other subjects. Come on, what you're telling me. You're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just take it upon yourself to put it in because you think that you've found a way around it? Come on.
If I may finish, Your Honor, I was about to say your ruling on our 3 motions and other acts motions was there were some gradations there. That you were clear that some things were absolutely out, and then you left the door open on other things. So I saw that distinction, and I thought to myself, clearly I know this is out, but you left the door open on other things. So I didn't interpret your ruling as this is absolutely never coming in, and I have practiced before you, Your Honor. I have filed other acts motions before you. Your practice oftentimes is to reserve ruling on those until you see the evidence. And I think you even said something to that effect at our motion.
I undoubtedly did.
So I thought this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith. All right. Would you come up, please, Mr. Rittenhouse?
I do have...
In good faith.
Your Honor?
Yeah.
I do have another item that I want to raise before the jury comes in and raise it with you. There was another acts motion with regard to the defendant being at Pudgy's bar after a court appearance in January in which he poses for selfies wearing a shirt that says free as fuck. I would like to ask the defendant if he posed for selfies after a court appearance with members of the public wearing that shirt. I know
Wow. What do you think?
Congratulations. I don't believe I had to watch the whole trial from the beginning because him entering the evidence and him doing just stuff. I don't trust that guy. He would be the shady lawyer to hire to
Okay.
get him paid off.
You guys ever heard? Okay, I'm putting a comment in. Good job. It says YouTube reject the comment. This usually means they think it's a scam. Try changing it a bit. Saying good job is a scam.
That's weird.
Yeah, I know. I don't know. I never heard that before. Good job on Michael. Huh?
What's up, Sable?
What's up, Sable?
Welcome in, everyone.
Number 9 video is coming up. After going, okay.
I've been like you around. You won't think something about that. You won't think something about that. I don't understand how you won't be naked. You don't understand.
Oh my God! What a crazy judge, isn't it?
Oh yeah. What was it? What was she saying?
If you read on the bottom.
Yeah, I know. I'm reading it.
Says, you know, that's
Oh
how
damn.
Angel talk sometimes. Angel.
I think they speeded up the sound.
Ah, okay.
Yeah,
That's what I thought so.
I think so too.
Video number 10 coming up. Oh no, it's
And from there, we'll get through this. Ms. Merchant.
Thank you, Judge. How often did Mr. Wade visit you at a place where you were living between 2019 and 2021?
So you want to start with the lie that he lived with me in South Fulton in 2019, a home he's never been to? That's one lie you told in your document.
Judge, I didn't ask her about that.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her. So why don't we break that up into smaller parts?
I didn't ask about living.
But you put in your, while we're talking about professionalism, she put in 3 different documents he lived with me.
Full opportunity to respond.
In
filed that with the court.
In 2019.
He's never been to South Fulton. In 2019, I lived in South Fulton. He has never been to my residence in 2019. Ever. Not once.
What do you guys think?
That's the lady that just got kicked off of Trump stuff, wasn't it?
Oh, okay, yeah.
Or something of that sort. I know she got kicked off, or yeah, she had to sit on the bench for something.
Ah, okay.
I need to start paying attention to these things more because, yeah, but she's been in the news for a minute. I don't know what she did, but
I just pick randomly, you know.
Yeah, it's okay.
They have some I cannot play because it's YouTube guidelines, you know.
caught on video using her phone during the trial of murdering a 2-year-old. Judging by the records from the courtroom, Judge Tracy Soderstrom did not stop scrolling through social media and texting. When her occupation could be seen from the side, she simply pulled out a drawer to hide behind it. Her interest in the phone continued even after the mother, who testified against her boyfriend who killed her 2-year-old son, cried on the stand.
Is the judge gone or the judge still there, the judge?
I don't know, but that person needs to be removed.
Oh, yes, I know. Does the judge know they have camera on top of the ceiling too? On the courtroom?
Yeah, it's right above their head. Like when you go
That's
into a
stupid.
courtroom, it's right above their
You know?
head.
How
I
dumb.
mean, like when you go in, I look for cameras when I
Especially
used
in
to
the
go in for my
courtroom. You have
brother
camera
or if
all
I
over,
had
you know?
court case, anything. You go in, you'll see the camera right above those people's heads. You could request those cameras, public records.
Oh, you could, okay.
Losing a lot of money by not having them. Because instead of issuing tickets to send the money to the state, we could be issuing tickets to send money into the county's pocket. But what I'd like to do is have an individual from the Board of Commissioners, Mark, someone from the Sheriff's Department, whoever would be interested in participating, someone from the townships, to get together to review, revamp our county ordinances. And also, I think it'd be good to have someone from townships so that we can cross-compare and make sure that we're not impeding on their already established ordinances.
Here, the Honorable Judge, Cassandra Lynn Morse-Bills, speaks at a town hall meeting as the Oscoda County prosecutor before she was eventually elected judge. She's explaining to the board members how they are in need of updating the ordinances for the county and its townships.
I want to get that started because if we wait until the last year, it's not going to get done. We need to start it now. So it's something, Mark, that I want to get started on. As soon as I get that assistant, I'll have time to do it. So.
What she is referring to here is her push to get Christy McGregor as her assistant prosecuting attorney. When Cassandra Lynn Morse-Bills became both district and circuit court judge for Oscoda County, Christy McGregor became the lead prosecutor.
Well, like I said, I read through a lot of them. There's a lot of redundancy. There's a lot of stuff that, like, I even question, can you do that?
That's what I say. A lot of it's unconstitutional. You can't. A lot of them are unenforceable.
And there's something that's so old.
Here the conversation is about the current ordinances and how some of them are unconstitutional and unenforceable.
And our county's losing a lot of money by not having them. Because instead of issuing tickets to send money to the state, we could be issuing tickets to send money into the county's pocket. Because instead of issuing tickets to send money to the state, we could be issuing tickets to send money into the county's pocket.
Ordinances are meant to protect the public and the community and instill a safe and healthy living environment. Here, the Honorable Judge, Cassandra Lynn Morse-Bills' only concern is the money that the county will get from updating these ordinances.
And we're just simply not doing it because we don't have updated ordinances. So, as the Board of Commissioners and your financial responsibility to the county, I think it's an important top of the agenda item to revamp these county ordinances.
It's very clear here, let's update the county ordinances so we get more money. That is why it's a top of the agenda item, as the Honorable Judge, Cassandra Lynn Morse-Bills states. This is a perfect example of small-town corruption in America. It's all about the money, and now this former prosecutor is both the district and circuit court judge in Oscoda County, Michigan. Yes, that means she determines if there is probable cause to bind over a district court case to circuit court, and then she is the same judge that hears that case in circuit court. The current Oscoda County prosecutor, Christy McGregor, is not elected as prosecutor and has been there since 2019. Public officials, such as a prosecutor, represent the state of Michigan and are to be elected by the people. Oscoda County seems to have multiple questionable practices, and as Judge Cassandra Morse-Bills sits as district and circuit court judge, she is at the center of a civil rights lawsuit involving her former assistant prosecutor, Christy McGregor. This video is part 1 of a series investigating Oscoda County government. Here you've seen proof firsthand hand of the main motivation for updating ordinances. Not for the people or the community, but for issuing tickets to put money in the county's
Because
pocket.
instead of issuing tickets to send money to the state, we could be issuing tickets to send money into the county's pocket.
I remember watching that one. Yep. Unhonorable. Dishonorable.
What do you think?
Very dishonorable, Judge. And she should never have gotten anywhere in those positions she's in. And how she's done it is I have no idea.
You know why? I think probably not a young judge become judge because either the family's in the court system or the family is the Senate. You know, that's what I'm thinking. She have family there,
Right.
got family.
Right.
It's gotta be. You know,
Somebody taught her to go and get into this position and take over.
Like, okay, if I was to play right now, the video, I won't get it.
Okay, we'll go.
Yep, that's true, Angel. Number 13 coming up.
That's horrible.
Yep.
But I like it. Because that's probably
The
how
next
she's.
video is all about Andrew kissing the ghost. I'm sorry, Andrew. I'm joking.
You're horrible.
I know I am.
A judge that's named involvement in the case, right?
Okay.
And the DCS that's involved. Now you've got somebody who's being threatened for arrest by the person they've reported for crime. That is in itself terrifying. Then now this woman, Lord, has to go in and face that judge who's presiding over criminal matters, knowing full well that she's being implicated in criminal activity. Now that judge can now go ahead and take revenge on her using the courts. And that is within the possibility based on the crimes that she was reported for. Regardless of whether or not she gets convicted or not, that's not the issue. The fact of the matter is that she made the complaint. And under the law, she has a right to make the complaint. And also, she also has a right to be protected from the person that she made a complaint from. Except this person is a judge. And the judge has demonstrated that she's using her power to punish her. So why would she not be afraid? Of course her safety is at risk because she can throw her in jail at any time. And she can use those armed men and women inside that courtroom to intimidate and coerce her, which she was doing. Yep. Now, when you do that, you know what that's called? It's called torture. That's prohibited under the Convention Against Torture, which under Article 6 of the Constitution is the supreme law of the land because it was ratified by Senate. You can't do that. Now, the judge is using her power in a wrong way. Doesn't matter whether she's a judge. Those kinds of things happen, and they're still crimes. Because she's wearing a black robe does not exempt her from criminal activity, which she is exercising.
Right. I understand what you're saying, sir. So I just need to look at what happened today, and then I'm going to add into my narrative that this needs to be forwarded to Royal Canadian Mounted Police and the FBI and the Indiana State Police.
Thank
you. So I will do that. That's really all I can do right now.
Yes. So basically today, the judge, the DCS, and were reported for crime. Simply put, the human trafficking, and then the other crimes tied to it. That's rather than going into that, simply sum it up. They told her about that, her involvement, that she shouldn't be in ruling on that case or any case relating to Lauren based on the conflict of interest, because she has a right to be protected from someone she's accused. The judge then threatened to arrest them, began to use the armed sheriffs and police officers, whoever's in there, with arresting them to stop them from asserting their rights.
Interesting. Good point.
Very good point. And I got two. I got two, but they're videos. So maybe one. But afterward.
I got like 5 more left. Number 14 videos. And I got 20 altogether. Coming up for number 14.
Not just a regular judge, a chief judge, decided, according to the GBI, to rob somebody. Yeah, a judge robbed somebody. And then when confronted about the robbery, the judge then threatens violence against the person who says, you need to stop robbing me. Put up his picture full mass here. All right, only in Georgia. This is from a place called Tattnall County, Georgia. You're looking at the chief magistrate judge, Eddie Anderson, 70 years of age. Chief Judge Anderson has been charged with threatening and robbery. Let me give you the background. The GBI, the Georgia Bureau of Investigation, arrested a Southeast Georgia judge accused of threatening a person after stealing produce from their garden. There's more. The GBI arrested Tattnall County Chief Magistrate Judge Eddie Anderson on Monday. He's charged with terroristic threats and violation of oath by a public officer. The GBI said the incident reportedly happened on June 22nd. Tattnall County Sheriff Kyle Sapp requested the GBI investigate the judge after a person came forward. Let's put up a picture of the sheriff. So here's what's happening so far. The sheriff gets a credible complaint that the chief magistrate judge of that county is committing theft, is committing robbery. Instead of investigating the judge himself because of their close relationship, he decides to call in the state investigative agency known as the GBI. The GBI, they then conduct their investigation, and they find that not only did this judge likely commit robbery, but also decided to threaten the individuals who owned the garden. The homeowner allegedly called Anderson to discuss the garden thefts. That's when the GBI said Judge Anderson made violent threats in the presence of other witnesses. Well, I mean, hell, he's a chief judge. Anderson, the judge, then turned himself in and was released on a signature bond according to the GBI. The GBI said the investigation is complete and will be given to prosecutors. Now, this is a nuance for the Georgia Bureau of Investigation that people need to be aware of. The GBI, they do not indict, they do not prosecute. They basically do investigations and they will relay that information directly to the prosecuting authority. So that's how they typically do it. So this is not abnormal for them to say, we have concluded the investigation and we're now turning over our findings to the prosecutor. It will be interesting to note because a lot of dynamics here. Number one, when the judge got arrested, it was a judge appointed by this judge that gave him a signature bond, number one. Number two, another dynamic that's interesting is the fact that even though this has been on record as far as a judge perhaps committing robbery, there does not seem to be a push in the local community for this chief judge to resign, even though the actions are substantial enough where the sheriff believed there was merit to the accusation. The GBI believed there was merit to the accusation. And I think now the prosecution is going to believe there is merit to the accusation that this judge, in fact, committed robbery and also decided to threaten physical harm against the individual he robbed. Quite fascinating. But once again, this gives you a glimpse into, let's say, rural town corruption. Do you think this was the judge's first time utilizing his position, his privilege, his authority to do something extreme? I don't think so. He's 70 years of age. I think he's been doing this for a long time. I think he was shocked that anybody decided to hold him accountable. All right, thoughts?
We're done, you know? Yeah, he could be he could be doing that for years, you know? Okay, next video coming up.
Matter, I want to be real honest with you because I had ordered an evaluation, and I want to thank you. You're very cooperative with Dr. Davis, and so on cases, the cases that I find are oftentimes the most difficult cases is when I have, and you can disagree with me. I want you to understand I will not be, I won't be mad at you if you disagree with me. But what happens in cases where somebody has a possible delusional disorder, one, they don't think they have it.
Of course.
And then, and two, it can interfere with the ability of a really good lawyer trying to explain to you how to move forward with your case, how to do what's in your best interest.
Yes, sir.
And so what's interesting, and I thought Dr. Davis did a really nice job on this eval, is that I can have somebody who suffers from a delusional disorder and it's compartmentalized. It's just a small area that they're very set on what they believe and think. And it doesn't affect their legal ability to understand or their legal competency. So somebody can go on with a delusional disorder as long as they're able to help their lawyer, as long as they're able to move forward with their case, as long as they're able to present appropriately in front of a jury. And so my worry about you was that when I talked to you a couple of times, that I felt that the delusional issues were getting in the way of your relationship with your lawyer. And so that's why I ordered the evaluation. So Mr. Pitts, let me ask you this. To the best of your ability, if you feel like you can't respond, I'll respect that. Are you able to work with Mr. Macker in a meaningful way, or are the issues that I have impairing your ability to appropriately represent him?
I think we're able to work together, Your Honor. I think he does have some concerns that may be valid because I think he does have. I think he knew one of the deputy or one of the sergeants that was involved with the arrest.
As long as you're able to work with him. Now, I will tell you that Dr. Davis picked up some of the issues that I was concerned about, but ultimately determined that he believed him to be legally competent.
I think he's very bright. I think he knows his case inside and out. I think he has been through a lot of trauma, so he is going to start therapy. I have therapy already scheduled for March 1st. And I think that would be good because I think he had an ex-wife that passed away. He had a fiance that passed away, and he's had some friend that passed. I mean, he's just had a lot of loss.
So let me ask you this, Mr. Pitts. As long as he's getting some treatment and you feel that you're able to move forward and work with him in a meaningful fashion, then I feel comfortable, based upon Dr. Davis's report, making some findings on the record that he is legally competent at this point in time to proceed. If, however, in the future you have concerns, please bring them to my attention.
What do you think, Westside?
That was a lot.
That was good. That was good.
Mm-hmm.
I got 4 more left.
Well, that judge probably, I mean, she's probably done that before, so.
Yeah, exactly. Mm-hmm.
Doesn't need to be up there and should have been out. Somebody should have said something a while.
Mm-hmm. Number 16.
Superior Court judge arrested.
Just after 4 o'clock Sunday afternoon, Prescott police pulling over a white Toyota 4Runner who a driver reported as potentially being intoxicated. The 4Runner's driver is Yavapai County Superior Court Judge Soleil Hancock, who admitted to officers she had been drinking.
How much did you drink?
A couple of glasses of wine.
Hancock questioning the field sobriety test's effectiveness.
The FSTs are like, we don't want that.
No, they're not, ma'am.
She stumbled during her first test and then blew a .158 on the scene. Later tests would come in at .219 and .214, all well above the legal driving limit.
Damn.
I remember that hoe. Oh. I mean, I remember her.
I didn't. I don't.
Yeah, it happened in Arizona, Prescott, Arizona.
Sean make a good point. Never go to the judge scorecard. The judge is paying for the other team. If it goes to chemical court, I know I'm guilty and I'm prepared to go to jail every time without flake truthful. Interesting, Sean.
Yeah, but there has to be a victim. If there's no victim, then the cop can't be a victim. Like, good DUIs are definitely a reason. I mean, yeah, he needed to get her off the road, but she shouldn't have been on the road anyway. She's a judge.
I have Signal. I have WhatsApp. I haven't used them in years.
That's Harris County Judge Lena Hidalgo back in May of 2022 making a claim that turns out was simply a lie. Search warrant affidavits filed by the Texas Rangers include proof that Hidalgo was in fact using the encrypted ultra-private messaging system WhatsApp to discuss a controversial multi-million-dollar COVID communication contract with her chief of staff. The same allegedly rigged deal that's resulted in the felony indictment of 3 senior Hidalgo aides. Aside from lying to me and the public for that matter, conducting county business in a technological black box could well prove a criminal violation of the Texas Public Information Act.
The question was about whether I conduct county business on the Signal app. I do not conduct county business on the Signal app.
So you did conduct county business on WhatsApp and other encrypted apps?
I already answered the question.
Wow.
The Texas Rangers answered it for you. Here's why all of this matters. The Rangers appear to be pursuing evidence that multiple folks on Team Hidalgo purposely erased messages regarding this COVID communication scheme. If that actually happened, the intentional destruction of public records could lead to additional charges, and the cover-up could be just as damning as the alleged crime.
Yep, get that hoe.
Yep.
Yep, throw it away the key.
Okay.
Put her on the ground somewhere. In a dungeon, so what?
We just literally told you 10 seconds ago that we're getting you a drink of water. He's out front right now getting you the glass.
Not 10 seconds ago. I want a drink of water now. Thank you. It's called Larry Lifford.
I tried him. He didn't answer.
Really?
Do you want the water? The water?
Yeah, I do.
Okay.
Larry Limbert.
Okay.
Larry Limbert.
After refusing to take a breathalyzer, Judge Doherty is charged with operating a vehicle while under the influence of alcohol.
Give me my phone so I can make a phone call.
Okay. Your phone is in a puddle of vomit in your car, which is on the side of... Can I finish? Which is on the side of the road that you crashed into.
Yes.
The tow company is out there trying to get it out. However, it is extremely snowy and slippery out. They are not able to get the vehicle out so far. So your phone is off the table right now. We don't have access to it.
Judge Doherty receives a fine of $1,075 and 180 days in jail. which the presiding judge reduces to $375 and 3 days in jail.
Well, that's
Her driver's
bullshit.
license is suspended for a year, and she's ordered to complete a driver's intervention program.
Is this the judge or what?
Yep, her friend. Her friend. She crashed the car too. So she probably hurt somebody. So now there's a victim, right? There's a
Yeah,
victim involved in that. The last one, there was no victim. She shouldn't have been driving.
exactly.
She was above the legal limit. This one has a victim. That one should have had a more harsher everything. She should be in
Yeah,
jail, not getting extra.
exactly. Not just prison. You know.
Yeah.
Last video for mine.
Okay.
24, and if you're a content creator, you're going to want to
Oh,
pay some attention to this. So in the last video, we talked about how the meta has already kind of changed.
Wrong video. Okay, that's it. It's 20 already. I'm bad.
Okay, my bad. I don't have mine ready.
Huh?
I don't have mine ready.
Well, take your time. I could tease Angel. You know? I could call the cops on Angel. Hey, Angel smoking cocaine, weed in the car. All the cops that come around me, he's caught.
That would be nice.
Oh, I'll make a short video, you know?
You're gonna make a short video?
Yeah, so hey, what's up? What's up? Guess what? How you doing, Justin? No time to see, brother.
Yeah, what's up, KS? You don't doubt it one bit. He still violated my rights. Yeah, that judge did.
What?
Hold on. I want to make sure this is the one I want. But I gotta let the thing play.
You know what? You know, like every time me and Angel cheese, we tease a lot. People get mad on the channels, you know, because they don't know who we are. Because me and Angel talk shit together, you know.
Yeah.
He make fun of me, I make fun of him. It's called good trashy talk, you know.
Right.
And he keep telling me, Tommy, because the Joe make me a model there, and he said, keep telling me, you know, dare you know. I told Angel, no. Every time he dare me, I don't do it, you know. I gotta surprise him, you know.
Right.
Yeah.
Where's that?
What are you doing today, Westside?
I'm supposed to be working, but I may do some classes instead and call it work.
Ooh, call out?
Call it work.
Did you get sick time?
Oh, I'm not gonna call out. I work from home.
Oh, you do?
Yeah, I work from home from when I want to work. Oh, let's watch. I wonder if we can watch this one.
Yeah, Justin is there. You are. Yep, it's
No.
kangaroo.
Oh yeah, that one. Okay, hold on. Yeah, I did have one.
Hey, bud.
I'm just trying to remember his name. I like that channel
Well,
too.
Justin.
What is his name, Chad?
He should not run for president when they have a trial on him. You know, that's
Right.
that's
But
that's
that's
not.
what they want. That's why they're doing it. So he should run at the same time.
I know he should not run.
No, he should.
Why?
Because that's what they want him not to run. That's why they got all these court cases and stuff on.
But he's running for president.
Yeah.
He should not. He's being on his own. That people will not be.
Damn, I can't find it.
Guys, don't get me wrong. I like Trump as a businessman. As president, no. No, that's my opinion. I like him as a person, but winning our country, no. Biden, I like him in the beginning. In the end, I don't because he's too old.
He's not doing right. He's not doing right. He's giving all of our Social Security away.
We gotta have president running young, not old.
Yeah. He also needs to stop giving our money away that we put into Social Security to.
It goes back for years. It goes in the beginning of time when after Jeff Kennedy passed away. That's started all go down here. It's all started back in the 70s after the 60s. You know what it should do in our country? Get free health care like Canada does. Some other country does. Hey, pay all your taxes. You know what I mean? That's my opinion. And lower the gas. That's another topic.
Yeah. I'm trying to find a good one. One I can use that's a YouTuber, but I forgot his name. So that's my fault. I wasn't ready. Because I don't remember the channel name. I wonder if I hashtag it come up.
You can't find it? Hey, what's up, John? Me for president, Gregory and Law,
No, because I want to play one that's allowed to on here.
Hi, Tracy and Todd Outdoors. How you doing? Thank you for coming in.
Can I change the subject and show this one where the kangaroo is punching an officer in the face during a capture?
Oh, yeah.
Okay. It's a short, too. Hold on. Pause.
Oh, I heard about that.
I got to find you. I wonder if they show it.
Did you hear a short Andrew made? He's kissing his car.
Did he make that on your channel or his channel?
His channel.
Oh.
Two of our officers located the wayward marsupial. Were able to keep eyes on him for several hours until just before 7 a.m. They were able to successfully apprehend the kangaroo. The officers actually just grabbed it by the tail and they were able to safely keep her contained in the area. Only one of the officers was actually struck in the face during the apprehension, but he'll be just fine and we won't be continuing the investigation. Just after 3 a.m., our officers were on patrol. Two of our officers located the wayward marsupial. Were able to keep eyes on him for several hours until just before 7 a.m. They were able to successfully apprehend the kangaroo. The officers actually just grabbed.
Damn, I wanted to see it. They never have the next one to be what you want when you're looking for it. I can't remember the other guy's channel.
Topic: Can't give a punch police.
Right. But you still have constitutional rights, and it's your natural right. So your natural rights oversees anything, even the Constitution. Just saying. Because the Constitution just goes right off your natural rights. Oh, this one was a good one, Gregory. Since we're saying courts, right?
Yeah.
Judges and courts. Puts everybody on notice. I like this guy. He was really good.
Hurry to Kohl's for great prices on fresh styles across the store. Save up to 25% on women's dresses. Then get juniors dresses.
Our last probable cause conference date 2/22, when neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to...
No, go ahead and make your record. I'm just telling you where I am.
Today's proceedings shine a light on a particularly grave matter, one that underscores the serious consequences of reckless behavior. Before Judge Simpson's bench stands Courtney, a young woman whose actions on a fateful night in January have brought her into court today, accompanied by her aggressive attorney. Because she was involved in a very serious DUI incident and didn't report it immediately, instead she drove home without calling EMS or anything for the other lady. Then Courtney allegedly did some really shady stuff in an attempt to hide and destroy evidence. This was a sad situation and no laughing matter at all, but something that was funny about this hearing was the way Judge Simpson put the defense attorney in check when he tried to get bold and was blaming Judge Simpson for discrepancies with the bond amount. But the real question is, will blonde Courtney walk out of there with a slap on the wrist? Stay tuned to find out.
Court calls case People versus Courtney Waldeck.
What do you think of that? I know we're going to watch it, but...
Interesting. I don't know. The judge don't send. You know, the law was asking. I'm gonna put in my records. You know.
Right.
What do you guys think?
That's good. Even though you had to do 6 months at 17.
You know the judge of that Angel.
Yeah. What happened?
The judge looks like Angel.
Looks like Angel?
Yeah.
You're too much.
And with Courtney Waldick. Judge, this is date time set for our second probable cause conference. At this time, if Waldick is inclined to waive her right to preliminary exam, and we've gone over those rights.
Waldick, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor, we do. And if that's the date, I'd like to address bond at the appropriate time.
Pardon?
Yes, I do waive, but in case this affects her pretrial date, I'd like to address bond at the appropriate time.
All right. So before I set the date, you may address bonds. Go ahead.
Your Honor, at the time my office charged this case, we requested a $100,000 cash surety bond. At this time, I am renewing that request. I understand that Ms. Waldick was given a $50,000 10% bond at the time of her arraignment. When we were last before Your Honor, I did not have the benefit of certainly I still don't have the report because the investigation continues to be ongoing. However, the information that is now available to me has grown substantially since we were last here. I will start off by going through essentially the timeline of what occurred here. In the early mornings of January 21st, 2024, people that were commuting to work or other locations observed and discovered the body of Miss Shelley Mason lying on the side of Prospect. It was unknown at the time what occurred to Miss Mason, who killed her, and who was involved, but the police were rapidly able to put together an investigation that led to them to be able to identify Miss Waldick as the person that killed Miss Mason. On January 20th, the day of the crash, Miss Waldick had been to a baby shower. She then went to Ray's in Ypsilanti with her friends, where she was drinking with her friends. She was texting people that were not present, somebody who was either her friend or her boyfriend. She had texted things to her boyfriend about meeting up with him later. In her text messages to her boyfriend, she indicated that she was out drinking with her friends and that she would be continuing to be drinking with her friends. She referenced to him that she wouldn't feel comfortable driving too far to meet him later, and I apologize for my language, but that she was going to be really fucked up. She did drive instead, though. She drove her car and she killed Miss Mason. After getting home, she didn't stop. She did not call the police, and she left Miss Mason there. After getting home, Miss Waldick saw her roommate's name was Sarah. And notably, we now know that Sarah actually drove that same route as Courtney a couple minutes ahead. And Sarah did see Miss Mason alive and walking on the road. And Sarah initially told the police that she saw Miss Mason walking on the shoulder of the road.
Growing up, I watched my single mom work so hard to raise me and my 3 sisters on a secretary's,
which is consistent with physical evidence in this case as well. But when Courtney got home, and this is sort of like Sarah's statement, as I understand it, as well as from the text messages that followed this, Courtney was quite hysterical. I'm going to call her Courtney. Courtney told Sarah that she had hit someone and that she needed to go back. Courtney and her roommate took over an hour to return to the scene. During this time, Courtney did not call the police. She did not ask for anybody to go out to the scene to help Miss Mason. Instead, she started texting her friends, her family. Her reaction to this was substantial and quite emotional. However, when Courtney came in for her interview with the police, which, mind you, was the Friday following, so she came in for her interview on January 26th. The crash occurred on January 20th. She told the police that she believed that she hit a deer. That this deer had just kind of popped out of nowhere, that she saw it just coming at her. We know from our interview with Sarah, the roommate, that Miss Mason was walking down the road. Sarah saw Miss Mason a couple.
Do you see something wrong with this?
Yeah, yeah. The judge. Okay, number one, the judge don't want to be here. You know.
Yeah.
The judge thinking something, and
He's
the
got
judge is freaking
something
wrong.
right.
Yeah, like this. You know. Probably the judge thinking about smoking weed. You know. I don't know.
Or being on a beach. And that chick is just figuring out how to spend the money.
Good one, Jeff. Good one.
Right, Jeff.
Everyone looks
a couple
bored.
minutes ahead of Courtney.
Everyone
Like they're
looks
not
bored.
like they don't want to hear it or something, huh?
No, I mean like the judge is bored, and the lady sitting down looks like she's the one doesn't want to. You know.
Like they
Probably,
definitely I don't know. Like
probably,
this I guess they have to, yeah. The
yeah,
injustice system, exactly.
yeah. Probably she's thinking about Angel.
And that Miss Mason was walking down the road.
You be too much sometimes, Gregory. You too much.
But what we also know is that Courtney didn't think she hit a deer. Sarah has now told us that Courtney came home and said, I think I hit someone. Sarah has confirmed for us that there was no mention of a deer. So when Courtney got home thinking that she hit someone without calling the police or stopping to help that someone, she continued to tell her friends and her family what she had done and what stress she was under. She didn't call the police. Leaving Miss Mason lying in the snow on the side of Prospect in who knows what condition. And I will say that the evidence of this case bear out that it is possible.
And she's still going. But yes, hey Simon. Exactly. Chase and tell. Judge is thinking dumb. She talks way too much, like my ex-wife. And I wish I was on a beach.
That if Courtney had just called the police, Miss Mason might still be alive. That's why we have crimes like this. That's why the penalties for crimes like this are so substantial, because Miss Mason may have still been alive and may still be with us right now. Miss Mason was a mother, she was a daughter, and she was a grandmother. And that woman was left on the side of the road without anybody with any help being sent her way. But not only did Courtney not call the police and not attempt to save Miss Mason in any way, what I now know is that Courtney then deleted approximately 150 messages on her phone. She deleted those messages that I referenced earlier about her not wanting to drive so far. She deleted a message about her being fucked up. And I will make clear for the record, the message says, I'm going to be fucked up, not that she currently was when she sent it. She deleted a message that said, I wish I would have called 911 immediately. And she also deleted, got to live with it and get my car fixed ASAP. Were deleted before her phone was turned over to the police. What she also did when she got home, and I know that defense counsel will argue that this was normal for her behavior, was she parked her vehicle in her garage. That car remained in the garage, and the garage door remained closed, as far as I understand it, with the garage inside. The police subsequently did a search warrant, and it wasn't until they were there with the search warrant that they were then given consent to go into the garage and discover the Jeep.
Hey, did you hear about this? There's a free $5,800 spending card going out to migrants. So just for kicks, I tried to get in on it.
Not sure, Sean. I've seen the judge. Oh, okay. I've seen this judge before too. He's got quite a few cases. But this is the same one with the DUI girl.
Your Honor, her guidelines as I score them are 19 months, 38 months, as I currently have them scored. My office requested a 100,000 cash surety bond at the time of charging this, and I am again renewing the request. Thank you, Your Honor.
Response.
Thank you, Judge. Obviously, I don't have to tell the court that Ms. Waldick stands here before you innocent until proven guilty. I'm not going to try the case in front of you, but I will address some of the things that were just said. First and foremost, there was an arraignment on January 28th where, as Ms. Hughes indicated, their office requested a $100,000 bond. A record was made. Prosecutor who attended the Zoom arraignment on that Sunday, myself, each made a record, and bond was set at $50,000, 10% with an alcohol tether. It's our argument to the court that that was not an unreasonable bond, nor was it an abuse of discretion. The fact that there's an ongoing investigation or this was charged early, that's not my client's fault. Maybe the prosecutor's office should have waited until the investigation was complete. With that said, Ms. Hughes indicates there was some drinking going on. My client turned herself in as a person of possible interest to the Washtenaw County Sheriff's Department to Detective Webb on January 26th. That date could have been sooner, and the police report indicates could have been sooner, but Detective Webb actually asked her to come in on Friday and not the Thursday beforehand. I appreciate Ms. Hughes said that no evidence that Ms. Waldick was quote unquote fucked up, but that maybe she had said she was going to be. That talks about something in the future. It doesn't mean that she was. This same witness that Ms. Hughes talks about, and I don't think Ms. Hughes would, this Sarah, quote unquote, Sarah, who has come forth and said some things, is the same Sarah who said she knew nothing about this originally. So now we have two different stories from Sarah, because originally Sarah said she had no idea what happened on the date in question. Ms. Waldick is now, since the arraignment, been before you twice here on February 22nd for her. She's been compliant with bond the whole 2 months to today's date that she has been on bond since being arraigned, with an alcohol tether the whole time before she was released from jail, with absolutely no issues. So this is the second time before you, but including going to the Sheriff's Department to speak to Detective Webb, she's appeared 3 times. She's not a flight risk. In addition to being on alcohol tether and having no issues, she's also reporting, checking into community corrections weekly. I've heard nothing today regarding any bond violations because I don't think there are any. There's been no change in circumstances as we see it since the date of the arraignment. Ms. Waldick is definitely not a flight risk, and she's not shown that she's a danger to the community in the past 2 months at all. Again, there's been no allegations of that. Judge, the 8th Amendment of the U.S. Constitution indicates that the court shall provide a bail that is not excessive. Stack versus Boyle, 342 U.S. 1, and People versus Edmond, 81 Mishap, 743 says bail that is set in an amount higher than reasonably calculated to give adequate assurance that the accused will appear is excessive under the 8th Amendment. Edmond goes on to say that courts have held that money bail is excessive if it is in an amount greater than reasonably necessary to adequately assure that the accused will appear when her presence is required. Court rules are designed to enforce these principles, Judge, and under these rules, there's a double presumption that a pretrial arrestee will be released without any case bail requirement. And that's stated in 765.6, MCLA 765.6, that in part, a person accused of a criminal offense is entitled to bail. The amount of bail shall not be excessive. Court rules go on to indicate what the money bail should be and what is required, what's considered in terms of setting bond. And those things under subsection F 6.106 say a defendant's prior criminal record. She has none. Defendant's record of appearance and non-appearance, or flight to avoid prosecution. She's been at everything. She's actually been at more.
Well, that flight issue also includes concealment of evidence, does it?
And I guess this came up at the bench when we were here on, surprisingly, on 2/28 or 2/20, our last probable cause conference date, 2/22, when neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed gainfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
From the people.
Nothing further, Your Honor. Thank you.
The court, in looking at the file and so that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. There were certain things that came to the court's attention that were not in the magistrate's mind nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could properly be argued before the court. What was not known, certainly to the magistrate at the time, was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprised counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages, which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Furthermore, there is, in terms of the issue of flight, of concealment of evidence and the like, now the deletion of text messages and other evidence in this case, which had just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant, the offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate, and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from $50,000 cash surety to $100,000 cash surety. Are they, counsel, just for the purposes of anything, are they able to do that right now, or?
We've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
She'll be taken back and do that. I think they can do that.
Hold on, sorry guys. We need to arraign her on the information. I apologize. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit court.
We'd waive the reading of the complaint to have the matter set for circuit court pretrial. I asked that she'd stay.
She stands. Depending on every for reading, standing mute, the court will enter a not guilty plea. Pretrial, technically, counsel, just, and I'll do it for the convenience of your schedule. Technically, she would be given the end date, but if it looks like you're going to post, I can give the out date. So
yeah, she'll be out.
She'll be out.
May 2nd at 1:30 before Slate Thursday.
Pretrial May 2nd, 2024, 1:30 before, that's a Slate Monday. Slate Thursday.
Judge, after that surety is posted, can I come back with proof so that, please?
Thank you.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and
That was a good one. And there's so many more on this. I think this is somebody just recording. I'm not sure if this is the actual person.
Hi, Gap.
Yeah, what's up, Gap? That's all I have.
Okay, guys. That's all. I'm going. Thanks for coming, guys. I'm gonna be back later on. I don't know yet. You guys take it easy. Thank you for coming in, guys, in the chat.
Later.
Sean, Angel, Gap, everybody. Hello, Victor. How you doing?
Bye.
I'm going to end this. I'm doing good. I'm gonna come back later and have more of the funny videos. I don't know yet. I'm thinking about it. Okay, guys, take it easy. Bye-bye.